School of Management Studies IGNOU presents an audiobook on the course MMPC-013 Business Law for MBA program. Block 3 Business Contracts Unit 5 General Principles of Contract Part 1.
After completing this unit, you should be able to identify different sources of mercantile law, understand the process of formation of contracts, explain the completion of contracts and jurisdiction, appreciate essentials of a valid contract and performance of the contracts, and describe the consequences of breach of a contract. Introduction. Every human being owes certain obligations to his family members and society. These obligations fall under the law of obligations that covers rights and duties arising between the individuals which are collateral in nature. The concept of obligations existed since the ancient period where the word of mouth was considered to create a bond. In other words, people will never leave from their words, that is, promises. The concept of primary obligations is one of humanity's greatest moral inventions. Wherever the promises are breached, they will be brought before the punch system for resolving the dispute between the parties. The law that is applicable to mercantile transactions is called the mercantile law, which includes general contracts, special contracts, and the law of insolvency and bankruptcy. This law relates to the rights and obligations arising out of mercantile transactions between traders or merchants. The movable property connected with mercantile is of two types, namely, choose in possession and choose in action. If person A had a ring on his hand which is stolen by a thief, A is a person having choose in possession. In other words, it means an individual who had legal possession of any property of movable nature and physically visible. Person A can resist the thief from snatching and recover it in a court of law. Recovering the amount due on a promissory note is considered as choose in action. This right of the payee or holder is not visible as compared to the ring. Further, it must also be noted that the law of contracts is applicable even to non-mercantile transactions. Sources of mercantile law. The main sources of mercantile law in England are the law of merchant or lex mercatoria, acts of parliament or statutes, common law of England and principles of equity. Lex mercatoria is the set of customs and usages which are recognized and enforced between merchants and part of the common law of England. The second one is the sanction of the state and most superior and most powerful source, and it overrides any rule of common law of equity. The phrase common law is used to denote the law that can be based on judicial pronouncements delivered from generations. King Henry II in 12th century established the common law courts or king's courts, which were also known as chancery or equity courts. Equity courts were not bound to grant relief in every case, as it was always a matter in discretion and governed by certain maxims. There were two maxims which the courts of equity act, and I quote, "He who seeks equity must do equity, and he who comes to equity must come with clean hands." Unquote. Prior to the Indian Contract Act 1872, the English common law, with some modifications suited to Indian conditions, was established for some time in the British India courts. After the establishment of courts at Madras, Bombay and Calcutta, the Hindu law and Mohammedan law and the law of defendants are to be considered for the application of law. The introduction of judicial system during the British India paved the way to introduce a legislation to recognize and legalize the concept of obligations and the practices among the people by the Contract Act 1872. The principles of law of contract are divided into four categories, namely the formation of the contracts, content of contracts, excuses for non-performance, and enforcement of contracts. Formation of contracts. A contract is an agreement enforceable in a court of law. An agreement is a set of reciprocal promises between the parties to the contract. These set of promises arises from an offer and acceptance from the parties to the contract. The contract may be express or implied, that is, it may be oral words or in writing, and even inferred from the conduct of the parties. It may be bilateral or unilateral contract. The former one refers to the involvement of two parties, and the latter refers to one party alone which can perform without the other. Agreements. Two or more persons agree mutually to undertake to do or not to do certain things through an agreement. For example, to deliver goods and to pay for them. This is not through a process of offer and acceptance. Number 2. Offer. The offer is a proposal by the offerer to undertake to do or abstain from doing something provided the offeree will also undertake to do or abstain from doing something. The offer contains two things, namely an expression of a willingness to be bound and a statement of what each party to the proposed agreement must do or not do. The person making the proposal is said to be called a promiser, offerer or proposer. The offer is of two types, namely specific offer and general offer. An offer to a specific person is a specific offer and the offer to public at large is a general offer. A's offer to sell his watch to B is specific and X offer to pay rupees 1000 to one who finds his lost dog is the example of general offer. Acceptance. The person to whom the proposal is made signifies his assent thereto. The offer or proposal has been accepted and which raises a promise. The person to whom the proposal is made or the person from whom the promiser seeks the assent is said to be called a promisee or acceptor. For example, when A signifies his willingness to sell his motorcycle for rupees 55,000 to B and B expresses his willingness to purchase for the said price, A is the proposer or the promiser or the offerer and B is the promisee or the acceptor. The proposal or offer or promise must possess certain characteristics. They are: number 1. It must be intended and capable of creating legal relationship between the parties to give rise to legal consequences. The set of promises raised between the parties must create legal relations. In the mentioned example, if A does not deliver the vehicle after receiving the price, or if B does not pay the price, the other party is having the right for breach of promise or obligation undertaken by the party in the offer or acceptance, as the case may be. The set of promises between parties which are not capable of giving rise to legal relationship or those which are not enforceable in a court of law are called social obligations or agreements. If a person makes a promise to his friend to take him to dinner at a restaurant and the other agrees, and if the promiser failed to perform his obligation, the promise could not be enforceable in a court of law as it was a social obligation. In other words, the social obligations, though set of promises, are incapable of giving rise to create legal relations between the parties. Number 2. The terms of it must be certain or capable of being certain. The terms of the offer must be certain, that is, without ambiguity or vagueness. In other words, the person to whom it was made must be in a position to understand and respond with his assent. Number 3. It must be different from number 1. Quotation, catalogue, auction, tenders, etc. These are regarded as invitation to make an offer for a particular thing specified therein by the person who gave the quotation or catalogue. Calling for tenders and auctioning of goods also come under invitation to make an offer. Number 2. Window displays at showrooms. This is also considered as an invitation to make an offer by the showroom owner from the public. And number 3. Railway timetables. Issuing of ticket by the railway authorities against payment to a commuter is amounting to an offer, but the timetables of the railways not regarded as an offer. Next point is, it must be offered to an individual or to the public at large. The offer is of two types, namely specific offer and general offer. An offer to a specific person is specific offer, and the offer to public at large is general offer. A's offer to sell his watch to B is specific, and X offers to pay ₹1,000 to anyone who finds his lost dog is the example of general offer. And last is, it must be communicated to the offeree. The offerer is having obligation to communicate to the respective offeree within reasonable time and manner. In order to convert a proposal into a promise, the acceptance must be absolute and unqualified. It must be expressed in some usual and reasonable manner. If the acceptance is conditional, the promiser can withdraw the proposal before the acceptance becomes absolute. Performance of the conditions of the offer or acceptance of any consideration for reciprocal promise which may be offered with a proposal is an acceptance of proposal. Essentials of valid acceptance. Number 1. The acceptance is not valid if it was communicated in the manner otherwise than mentioned in the offer. English law invalidates such acceptance. But Indian law says that after receiving the acceptance in different manner, the receiver must inform the acceptor that your acceptance is not accepted unless and until it is communicated in the specified manner, failing which the proposer accepts the acceptance. Number 2. The offerer may waive the communication of an acceptance. Number 3. Acceptance must be made before the offer lapses or revoked by the proposer. And number 4. It should be absolute in terms with the offer. Variation or addition of terms to the original offer is not a valid acceptance. A statement of fact to an offer does not amount to acceptance. Lapse or revocation or rejection of offer. The proposal of the offerer lapses on the death of the proposer and before the offeree accepts. There will be no contract in English law even if the acceptance was made in ignorance of the death of the offerer. But under Indian law, there will be a valid contract except where the acceptance is made with knowledge of the death of the offerer. This rule will be applicable in case of insanity of the offerer also. If the offeree does not respond to the offer in the manner prescribed or within the reasonable time, there will be no contract. The term reasonable time is used in wider sense, which varies from the circumstances of each case. The offerer is at liberty to revoke the offer by communication at any time before the offeree makes the acceptance of it. Even if the offer is valid for a fixed term or period, the offerer can communicate the revocation of the offer before the offeree accepts. The offeree can communicate his rejection to the offerer, or he may take counter offer, or he may accept with certain conditions. Completion of contracts and jurisdiction. Generally, the contract completes when the acceptance of the offeree is posted or put into transmission. It was made at the place where the acceptance is received by the offerer. It was easy to determine the completion of contract when the parties negotiate in person, but it will be difficult to determine in case of negotiation by post, telegram, telephone and mail, etc. The contract in case of instantaneous contracts completes only when the communication of the acceptance is received by the offerer. In other words, the contract is said to be made at the place where the acceptance is received, but not at the place where it is transmitted. The United Nations Commission on International Trade Law, that is UNCITRAL, adopted the Model Law on Electronic Commerce in 1996. As a result, the Information Technology Act 2000 governs the rules relating to the e-commerce contracts. The offerer and acceptor are substituted by expression soriginato and addressee. The electronic record sent by the originator may be received intact or it may vary. The addressee has to acknowledge the receipt of electronic record by communication automated or any mode or by conduct. The contract completes where the principal place of business of the originator, in case of more than one place of business of originator or addressee, the principal place of business of the originator or addressee, and in case of no place of business, his usual place of residence will be considered as the completion of the contract for the purpose of jurisdiction. Essentials of a valid contract. Consideration, capacity to contract, free consent and legality of consideration and object are some of the essentials of a valid contract. Let's discuss them in detail. Number 1. Consideration. Consideration is one of the essential conditions for the validity of contract. The essential condition for the enforceability of simple contracts is consideration, and the rule is expressed by the Latin maxim ex nudo pacto non oritur actio, which means out of nude pact no cause of action arises. It can be understood in the sense quid pro quo. A valuable consideration in the sense of the law may consist either some right, interest, profit or benefit accruing to one party, or some forbearance, detriment, loss or responsibility given, suffered, undertaken by the other. An act or forbearance of one party or the promise thereof is the price for which the promise of the other is bought, and the promise thus given for value is enforceable. When at the desire of the promiser, the promisee or any other person has done or abstained from doing, or does or abstains from doing, or promises to do or abstains from doing something, such act or abstinence or promise is called a consideration for the promise. The analysis of all these definitions say that the consideration may be executed or executory. In a contract to deliver a watch by A to B for ₹100, A and B gained money and watch, and in another standpoint, A and B lost watch and ₹100 respectively. The law insists more upon the presence of the element of detriment to the promisee B and then the presence of benefit to the promiser A. A promise from one party to the other and a promise from the other to the former support the consideration. In other words, the reciprocity of promises between the parties establishes the consideration. The absence of consideration makes the contract void. This principle has certain exceptions recognized under the provisions of law. They are: number 1, where the contract reduced into writing and registered and made out of natural love and affection between the parties standing in near relationship to each other. Number 2, where the contract is to compensate the person who voluntarily rendered services in the past. In other words, past services rendered at the desire of the promisor constitute a valid consideration in India. But under English law, past consideration is not valid. Number 3. Where a promise is made to pay a time-barred debt, it does not require a fresh consideration. And number 4. Where a gift between the donor and donee is not affected for want of consideration if it is registered and attested by 2 witnesses. Though consideration is necessary, it need not be adequate. The adequacy and sufficiency of consideration is immaterial. It is said that peppercorn is sufficient for purchase of an elephant. The consideration is to move from whom is the question to be determined for the enforceability of the contract. It must proceed or move from the promisee. Under English law, a stranger to a consideration cannot sue. In other words, the promisee cannot sue the promisor if the consideration doesn't move from him. But under Indian law, a stranger to consideration can sue. The rule stranger to contract cannot sue is the same both under English law as well as under Indian law. This principle was explained by the doctrine of privity of contract. Under English law, there are certain principles which are fundamental. A person who is a party to the contract can sue on it. This principle has certain exceptions recognized by the provisions of law as: number 1, where a trust is created for the benefit of a party, the beneficiary can enforce it though he is a stranger to contract. Number 2, where there is an acknowledgement of liability or estoppel. For example, A receives money from B to pay it to C. A admits to C the receipt of this amount and liable to pay it to C. Apart from these, the Indian law recognizes 2 more exceptions. They are: number 1, a benamidar in whose name a property was registered is entitled to enforce though he is not a party to the contract. And number 2, in family arrangements such as maintenance or expenses for marriages of female members, the beneficiaries can sue though they are not party to the contract. Consideration and discharge of contract. The doctrine of consideration is not extended to the discharge of contract. The reciprocal promises between the parties constitute consideration. Subsequently, if both the parties agree not to enforce the contract, also constitute consideration in India. But it is not so in English law. Till 1947, the law of England applied the doctrine of consideration not only to the formation of a contract but also to its discharge. It was pointed out that a creditor might accept anything in satisfaction of his debt except a less amount of money. A canary or peppercorn may be accepted in full discharge of a debt, but a part payment of the debt cannot be accepted so as to operate as full discharge of the debt. There are certain exceptions to the rule in Penal's case. They are: number 1, under the scheme of composition, if the debtor agrees to pay a portion of the debt, discharges liability without application of the doctrine of consideration under English law. Number 2, in case a third party pays a part of the amount, less than the amount due from the debtor discharges the debtor without application of the doctrine of consideration under English law. And number 3, the doctrine of estoppel or quasi-estoppel neutralize the rule in Penal's case. Under Indian law, a contract may be discharged by what is called an accord and satisfaction, that is mutually agreed settlement. The English law allows the delivery of horse against the payment of debt, but not accept the delivery in future to discharge the debt. The part payment of debt is also not accepted as accord and satisfaction. Number 2, capacity to contract. There are certain persons in law who are incapable wholly or in part of binding themselves by a promise or of enforcing a promise made to them. In mercantile contracts, lex loci contractus, that is, the law of the place will prevail, whereas in case of land, lex situs, that is, the law of the place where the land is situated, will be applicable. The incapacity of a party to enter into a contract will arise in 2 ways, namely, on account of status or on account of mental deficiency. The former would occur on the grounds of political consideration and expediency, and the latter is imposed to protect the interest of the disabled person. The incapacity of a party is broadly divided into 2 categories. One, which arises out of status of an individual for certain reasons. These reasons are: number 1, political or civil status. For example, where the contracting party is a ruler of a foreign state, ambassador or envoy or alien enemy, or a convict or a bankrupt. Number 2, profession of the contracting person, for example, barrister. Number 3, incorporation. And number 4, marriage. The other, which arises from mental deficiency, that is soundness of mind of the person contracting, in case of: number 1, minors; number 2, insane persons; number 3, idiots; number 4, drunken persons. The person below the age of 21 is called as an infant as per the Infant Relief Act 1874 under the common law, and the person below the age of 18 is a minor as per the Family Reforms Act 1969 under English law and Indian law respectively. He is a person who is not a major. The Instant Relief Act 1874, which modified the common law of England, allows an infant to enter into a contract for these reasons: number 1, for necessaries; number 2, beneficial contracts of service; number 3, contracts involving recurring rights and duties, for example, an interest in property binding on him unless he rescind them either during infancy or within reasonable time of becoming a major; and number 4, an isolated act or a contract to pay for goods supplied other than necessaries were voidable and not binding on him unless he ratified them within reasonable time after attaining majority. The law relating to infants or minor contracts is at present provided in Minors Contract Act 1987 under English law. The Indian Contract Act 1872 provides that the contracting party must be a major. A person becomes major on attaining the age of 18 years. The provision of the Contract Act does not specify whether a minor's contract is void or voidable. The analogy of English law made such contracts as voidable and becomes valid by ratification on attaining majority. The Privy Council in Mohoru Bibi versus Dharamdas Ghose pointed out this erroneous view and held that a minor's contract is void ab initio. There will be no question of avoiding it or ratifying it. Similar to English law, the person supplying necessaries to minor is protected under Indian law. The binding nature of a guardian contract on the minor is depending on the legal power of the guardian to enter into a contract or not. There will be no estoppel against a minor as both the parties are aware of the truth. The power to order restitution in India is wider than England. It was clear under Indian law that any benefit, even cash received, may be directed to be restored, but it must be shown that the minor or his estate derived some benefit therefrom. Mutuality of mind. The parties to the contract must have consensus ad idem, which means mutuality of mind as to the subject matter of the contract. The lack of mutuality of mind makes the contract void. A had two houses, namely X and Y. A enters into contract with B to sell, keeping X house in his mind, and B entered into contract with A by keeping Y house in his mind. This results a contract void due to lack of consensus ad idem on the subject matter of the contract. Number 3. Free consent. The consent of the party to the contract is said to be free if it is not caused by coercion, undue influence, fraud, misrepresentation, and mistake. Let's try to understand these terms in detail. Coercion. The committing or threatening to commit any act forbidden by the Indian Penal Code, or the unlawful detaining or threatening to detain any property to the prejudice of any person whatever, with the intention of causing any person to enter into an agreement, is called coercion. The term duress in English law is defined as causing, threatening to cause bodily violence or imprisonment with a view to obtain the consent of the other party to the contract. Coercion in Indian law has a much wider connotation than duress in English law. The main distinction between coercion and duress, as the first denotes the offence forbidden by Indian Penal Code, whereas the latter confined only to bodily violence and imprisonment. The presence of coercion or duress in both Indian and English law was an invalidating element for the enforceability of contract. Undue influence. This was also called as constructive fraud. It covers all the contracts where one party will be in a position to dominate the will of the other because of relationship while entering the contract. This influence can be presumed in existence among these relationships, and they are parent and child, guardian and ward, trustee and beneficiary, spiritual master and disciple, lawyer and client, and doctor and patient. The contract between the parties with these relationships turns it voidable by presuming the existence of undue influence of the former against the other. It is the burden on the former party to prove that he was not in dominating position and that his position was not used to obtain the consent of the other. Fraud. The acts of a party to a contract establish fraud while entering into a contract with the other are: Number 1. The suggestion of a fact of that which is not true by one who does not believe it to be true. Number 2. The active concealment of a fact by one having knowledge or belief of the fact. Number 3. A promise made without intention of performing it. Number 4. Any other act fitted to deceive. And number 5. Any such act or omission as the law specially declares as fraudulent. The mere silence on the part of party does not amount to fraud, but silence amounts to fraud where there is a duty on the party to speak. Misrepresentation. A party may give his consent to enter into a contract because of misrepresentation of the other. These false statements or misrepresentations may be either inducing cause of contract. These statements may be called as innocent misrepresentation and willful or actionable misrepresentation which amounts to fraud. A misrepresentation consists of certain ingredients. They are: number 1, failure to disclosure of a fact. Number 2, such non-disclosure must relate to a fact, not to an opinion. Number 3, such representation must be untrue. And number 4, it must be material to influence the other to enter into a contract. Any representation made by a party with full knowledge of the fact that it is not true, or without belief in its truth, or recklessly not caring whether it is true or false, it is said to be fraudulent. Whenever the consent of the party is obtained in the absence of free consent, the contract is voidable at the option of the party whose consent is not free because of the presence of coercion or fraud or misrepresentation. The aggrieved party of such voidable contract had an option to continue the contract or rescind the contract and be entitled for damages. Further, the contract induced by undue influence can be set aside, or it is voidable at the option of the party whose consent was obtained by dominating the will of the aggrieved party. Mistake. While entering into a contract, the parties to the contract may be under a mistake. This mistake may be as to a fact or law. Mistake of fact may be as to subject matter of the contract. For example, regarding the existence, quality or quantity, etc., nature of contract, person entering into contract. Mistake of law may be regarding foreign law or ordinary law, law of our country, or private rights of the contracting parties. Another classification of these mistakes is bilateral and unilateral. A mistake of fact in the minds of both the parties negatives the consensus ad idem, and the contract in such cases is void. Where both the parties to an agreement are at mistake as to a matter of fact essential to the agreement is void. This will come under the classification of bilateral mistake. In case of unilateral mistake, that is where only one party to a contract is under a mistake, the contract, generally speaking, is not valid. A contract is not merely voidable because it was caused by one of the parties to it being under mistake as to a matter of fact. A contract is not voidable because it was caused by mistake as to any law in force in India. But a mistake as to a law not in force in India has the same effect as a mistake of fact. Last is legality of consideration and object. Apart from the other essentials discussed so far for the formation of a valid contract, the legality of consideration and object is a must. The unlawful agreements may be classified as: number 1, illegal, where the agreement is contrary to the statute law. Number 2, immoral, where it is opposed to public morals, for example, agreement for illicit cohabitation or separation between husband and wife. And number 3, opposed to public policy, where the agreement is forbidden as conflicting with the well-being of the state. For example, agreements tending to the abuse of legal process, agreements in restraint of trade, agreements in restraint of marriage, agreements in restraint of parental rights, etc. Where a part of consideration or object of an agreement is unlawful, the agreement is void. In case of non-separation of the unlawful part from the agreement, the total transaction will be void. The rule applicable to separate the unlawful and lawful part is known as blue pencil rule. In such cases, the lawful part, which is separated by drawing blue pencil lining from the unlawful part, can be enforceable. A contract without consideration is said to be void, with certain exceptions. They are: number 1, every agreement in restraint of marriage of any person other than a minor is void. Number 2, An agreement in restraint of trade is void with an exception where goodwill is sold or as per the provisions of the Partnership Act 1932. Number 3. Any agreement in restraint of legal proceeding is void with an exception of arbitration agreement. Number 4. Where the meaning of an agreement is not certain or capable of being certain are void. Number 5. Agreement by way of wager is void. Number 6. The performance of the contract is depending on the happening or non-happening of an event at a future date is called as contingent contract. If the happening of the event is impossible, the contract becomes void. Number 7. The enforcement of a contingent contract is possible before the impossibility of its occurrence. The promise of A to pay B a sum of money if B marries C and C marries D. Marriage between B and C is impossible during the lifetime of A makes the agreement void. Number 8. The contingent contract to do or not to do within a specified period becomes void after the expiry of the time. And number 9. Any agreement contingent on impossible events is void.
We were listening to the audiobook by the School of Management Studies IGNOU for MBA program. Course code MMPC-013 Business Law. Course coordinator Professor K. Ravi Shankar. Voiceover by Harpreet Kaur. Edited by Savita Rana. Program assisted by Tarannum Jahan and Jagbandhu Jana. Program produced by Dr. Manoj Kumar Singh. This program was brought to you by Electronic Media Production Center of Indira Gandhi National Open University.